officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors." End of quote. During the debates of the Federal Convention of 1787, James Madison, Alexander Hamilton, and others relied heavily on Sir William Blackstone's work, Commentaries on the Laws of England, which Madison described as, and I quote, "a book which is in every man's hand." With his work, Blackstone discussed high misdemeanors, which included many crimes against the king and government, including maladministration. According to Blackstone, maladministration applied to high officers in public trust and employment and was punished by the method of parliamentary impeachment. It is from this understanding that the framers selected high crimes and misdemeanors for the impeachment clause in our Constitution. The term high crimes and misdemeanors had a limited and technical meaning that was well known to the framers. It was a term of art. As early as 14th century England, high crimes and misdemeanors were a category of political crimes against the state and were tried in parliamentary impeachments. It should be understood that the word high in high crimes and misdemeanors is a modifying adjective and also applies to the word misdemeanors. High misdemeanors was applied in impeachment proceedings conducted by Parliament long before there was such a crime as a misdemeanor as we know it today. Misdemeanors alone referred to criminal sanctions for private wrongs. High crimes and misdemeanors were charged against officers of the highest rank and favor with the Crown, or who were in judicial or executive offices, and because of their stations, were unindictable by ordinary rules of justice. For those individuals who were not indictable by the ordinary rules of justice, the Founding Fathers, in their subtle brilliance, sought to have something akin to crimes and misdemeanors that allowed them to impeach for great and dangerous crimes committed against the state. As we know, the Founding Fathers specifically adopted the phrase high crimes and misdemeanors. The emphasis on high misdemeanors is important in this context because the House of Representatives has not alleged treason, they have not alleged bribery. Their case rests on whether the articles charged are the types of high crimes and high misdemeanors intended by our framers. In defining high misdemeanors, Blackstone stated, and I quote, "The first and principal is the maladministration of such high officers," end of quote. However, the Founding Fathers specifically chose not to include maladministration as a basis for impeachment. When George Mason and James Madison debated the specific language of the impeachment clause, Mason stated, and I quote, "Why is the provision restrained to treason and bribery only? Treason, as defined in the Constitution, will not reach many great and dangerous offenses. Hastings is not guilty of treason. Attempts to subvert the Constitution may not be treason as above defined." End of quote. Mason then moved to add after bribery or maladministration, to which Madison replied, and I quote, "So vague a term will be equivalent to a tenure during pleasure of the Senate." End of quote. The framers knew what they were adopting when they chose high crimes and misdemeanors. They explicitly rejected maladministration and other vague terms in favor of more specific allegations which had a limited and technical meaning. In the first article of impeachment before the Senate, the question is whether abuse of power as a charge on its own is an impeachable offense. The answer is no. Abuse of power does not have a limited meaning and is as vague as maladministration. The framers actually discussed abuse of power and rejected it. At the Virginia Ratifying Convention, James Erdahl, one of the first justices of the Supreme Court, stated, and I quote, "No power of any kind or degree can be given but what may be abused. We have, therefore, only to consider whether any particular power is absolutely necessary. If it be, The power must be given, and we must run the risk of abuse." End of quote. In the first article of impeachment, the House has claimed that the abuse of power is within the scope of high crimes and misdemeanors. I believe the Founding Fathers saw abuse of power as an inherent risk within the delegation of that authority. The framers did not intend impeachment proceedings to be brought every time an abuse of power is alleged. In the second article of impeachment, the House alleges the President obstructed Congress when he refused to comply with congressional subpoenas. The President rejected the legitimacy of those subpoenas. The House then failed to pursue through the courts, rejecting the court's rightful role in settling disputes between the two branches of government. The separation of powers doctrine recognizes executive privilege as a lawful exercise for the President to protect both presidential and deliberative process communications. The House showed a deliberate disregard for the proper role of the judicial branch and now expects the Senate to gather evidence after they have already impeached. Alleging an obstruction of Congress charge before the House exhausted its remedy for judicial relief would change the balance of power between our co-equal branches of government and ignore the rightful place the courts hold in arbitrating differences between the executive and legislative branches. No branch of government is above the Constitution. We are obligated under oath of office to support and defend it. Article 1, Sections 2 and 3 of the Constitution state, and I quote, "The House shall have the sole power of impeachment, and the Senate shall have the sole power to try all impeachments." The framers intentionally separated these authorities. The Senate does not have the authority to impeach. However, the Senate does have the authority to judge the sufficiency of articles presented to it. The Senate, as a trier of facts, should not overstep its role. It is the House's responsibility to bring the evidence to make their case, not simply make an allegation. This does not mean that the Senate cannot call witnesses, but it most certainly should not be the Senate's obligation to do so because the House failed to do so in the first place. Upon the founding of the Senate, James Madison explained that the Senate would be a necessary fence against the fickleness and passion that tended to influence the attitudes of the general public and members of the House of Representatives. George Washington is said to have told Thomas Jefferson that the framers had created the Senate to cool House legislation, just as a saucer was used to cool hot tea. For impeachment, there can be no difference. When the House is ignited by partisan passions eager to reach a desired result, the Senate must be cool and firm in its heightened review. In recognizing the haste and half-hearted attempt by our colleagues in the House, the Senate must also recognize these articles of impeachment to be wholly insufficient and not warranting a removal from office. Let this decision lie in its rightful place with the electorate. The Senate has conducted a fair, impartial trial. We did our due diligence and fulfilled our constitutional duty. And now it is time to bring this process to a close and get on with the business of the American people who sent us here. I will vote against the articles of impeachment, and in keeping with the constitutional intent our framers expected. Thank you, Madam President. I yield the floor and ask unanimous consent that citations for my remarks be printed in the record.
Without objection.
Madam President,
Senator from New Hampshire.
I come to the floor this afternoon to express my profound disappointment. This is a sad moment in our nation's history. I, like all of us in the Senate, came to this body to try and make a difference for our constituents, to address the kitchen table issues that affect their everyday lives. Lowering prescription drug costs, rebuilding our crumbling infrastructure, making college more affordable, protecting our environment, helping our veterans, supporting our small businesses. So many of the things that I and others here have worked on. Now, critics have argued that the impeachment process is nothing more than a political attack orchestrated by those who have wanted to remove this president since his election. I flatly reject that argument. I have repeatedly expressed my reluctance to the use of impeachment. Unfortunately, it is this president's disturbing actions that have put us in this position. President Trump went to great lengths to try and force the Ukrainian president to help smear Joe Biden, his political rival. This scheme included withholding military aid and withholding a meeting at the White House with the Ukrainian president. Each of us here took an oath to support and defend the Constitution. And the Constitution requires us to do this job. It tells us that the Senate shall have the sole power to try all impeachments. And after the power to declare war, the power to impeach is among the most serious and consequential powers granted to Congress by our founding document. When we all stood here at the beginning of this trial, we took an oath to do, and I quote, impartial justice. That should mean a commitment to seek all of the facts. A fair trial means documents and witnesses, facts that will help us better understand the truth. Previous Senates understood this. In fact, every Senate impeachment trial in history included witnesses. Most recently, in the Judge Porteous impeachment trial in 2010, when I was one of the senators who served on that impeachment committee, we heard from 26 witnesses, 17 of whom had not testified before in the House. We believed then that Senate witnesses were important for an impeachment of a district court judge, federal district court judge. So why wouldn't we want witnesses in something as important as an impeachment of a sitting president? We know that documents exist that could help shed more light on this case. We also know of other witnesses with additional firsthand information that we have yet to hear from. We have one witness in particular, former National Security Advisor John Bolton, who has told the world he has relevant information, and he's willing to testify. And yet, despite all of that, the Senate, on a partisan vote, refused to listen to Ambassador Bolton or any other witnesses. Members of this institution have willfully turned their backs on important, relevant, firsthand information. On the articles of impeachment before us, I've listened to the extensive arguments from both the House managers and the defense counsel for the president. I believe the evidence clearly shows that the president abused his power, which has been acknowledged by several Republican senators, and he obstructed Congress, which is why I will be supporting both articles of impeachment. On the first article of impeachment, it is my strong view that the House managers have proved that President Trump withheld military aid and a White House meeting from the government of Ukraine to further his own political interests in the upcoming presidential election and to damage the candidacy of his opponent. The evidence presented to the Senate was overwhelming. Further supporting the House manager's case, the Independent Government Accountability Office, the GAO, concluded that the withholding of military aid to Ukraine was improper and illegal under the law. The nature of the president's offenses outlined in the articles strike at the very heart of our democratic system. Our founding fathers were very concerned about both foreign interference in our democracy and the executive abusing the powers of the office for electoral gain. James Madison warned of a president that, quote, might betray his trust to foreign powers, end quote. George Washington, in his farewell address, warned us all, quote, to be constantly awake, since history and experience prove that foreign influence is one of the most baneful foes of Republican government, end quote. As a senator who sits on the Armed Services and Foreign Relations Committees, I am keenly aware of the serious national security interests that are at stake here. This body, the Senate, has been deeply supportive of an independent Ukraine and a strong U.S.-Ukraine relationship. And I've joined with senators from both sides of the aisle in support of providing lethal assistance to help Ukraine better defend itself from Russian aggression. We continue to do so because it is in our direct national security interest to support our partner in the midst of an active war with Russia, our adversary. And we know that Russia has serious designs on Eastern Europe. They're looking at ways to influence European countries, former Soviet republics, where they think they can make inroads, and Ukraine is standing at the wall between Eastern Europe and Russia. I also joined the bipartisan leadership of the Ukraine caucus in writing a letter expressing deep concerns over reports that aid to Ukraine was being held up. This September 2019 letter clearly stated that the administration's hold on assistance would do lasting damage to the Ukrainian military and would undo the progress made by Ukraine to defend itself. That was a bipartisan letter. Putting our national security at risk in order to secure personal political favors is an unacceptable abuse of power, and that is why we are here today. In response to the overwhelming evidence presented by the House managers, the President's counsels failed to refute these serious allegations. Their arguments that President Trump was focused only on the national interest are not supported by the facts. The President has never demonstrated an interest in rooting out corruption in Ukraine and has a troubling pattern of personally seeking political dirt from foreign governments. I worry that this behavior will continue. The 2020 election is 9 months away, and the President continues to suggest that he would consider receiving political help from foreign governments. Just recently, the President suggested that China should also investigate the Bidens. Now, with respect to the second article, dealing with obstruction of justice, the House managers have also presented overwhelming evidence that President Trump obstructed the investigation into his conduct toward Ukraine. The President has repeatedly denied the House of Representatives constitutional authority to conduct an impeachment inquiry. The President ordered federal agencies and officials to ignore all requests for documents and all subpoenas. Those agencies obeyed the President's order, and not a single document was turned over to the House. In total, 9 witnesses called by the House followed President Trump's order and refused to testify under subpoena in the impeachment proceedings. This is an unprecedented attempt to thwart Congress's constitutional authority to exercise the impeachment power. Even President Nixon instructed his White House staff to voluntarily appear before Congress and to testify under oath. Despite the administration's stonewalling, many courageous officials did come forward to testify at great personal and professional expense. I want to thank those who testified. Their bravery and commitment to the truth should be commended. But if the President is allowed to completely stonewall congressional impeachment investigations into executive branch abuses, then the congressional power of impeachment is meaningless. As a senator, I never imagined I would have to participate in an impeachment trial of a sitting president. These proceedings cause strain and division, not just here in Congress, but across the country. I would much prefer that Congress be engaged in the critical bipartisan work that's needed on important issues, things that can improve lives across this country and move our nation forward. I hope that this body will move on from this disappointing day and will get back to the business of the country. Thank you, Madam President. I yield the floor and note the absence of a quorum.
Clerk will call the roll.
Mr. Alexander. Madam President.
Senator from California.
Madam President, I ask unanimous consent to speak on morning business.
The Senate is in a quorum call.
I ask the quorum call be suspended.
Without objection.
Thank you very much.
Yes.
Madam President, the decision to remove a president at any point in their term, particularly 9 months before an election, is not something we should take lightly. Impeachment should not be a tool that Congress uses to settle policy or personal disagreement. Instead, it should only be used if a president engages in misconduct so egregious that their conviction and removal is necessary and in the nation's best interest. Alexander Hamilton wrote in Federalist 65 that the founders chose the Senate as the most fit dispository of this important trust to make such a weighty decision. They actually had faith that this body could rise above pure partisanship to conduct a fair trial and reach a just verdict. In this case, however, we could not reach bipartisan agreement, not even on how to conduct the trial. It's a fact that for the first time in this nation's history, the Senate will render a verdict in an impeachment proceeding without hearing from a single witness and without reviewing key documents that have been withheld by the executive branch. As recently as last Friday, OMB admitted it continues to withhold key documents. Let me provide an example. In a court filing, an OMB lawyer wrote that 24 White House emails were being withheld because they, quote, reflect communications, end quote, by the president, vice president, or top advisors on the, quote, scope, duration, and purpose of the hold on military assistance to Ukraine, end quote. Proceeding without such vital evidence is a real mistake. I came to this trial with an open mind to listen to the case presented by both sides and then to make a determination based on the facts. After hearing the House manager's case, it is clear that President Trump withheld U.S. aid in an effort to obtain Ukraine's assistance to win re-election by asking that Ukraine launch and make public an investigation into Joe Biden, Mr. Trump's political opponent. The president's legal team tried to argue that this didn't happen, but without seeing key documents and hearing from key fact witnesses such as John Bolton and Mick Mulvaney, top advisors with firsthand knowledge of the president's conduct and motives, their arguments were not persuasive. So, after weighing the evidence available to us and considering the president's pattern of similar misconduct, I will vote yes on the articles of impeachment. The House presented a compelling factual case. Congress appropriated nearly $400 million in foreign aid to Ukraine, an ally engaged in a war with a major power, Russia. It was signed into law by President Trump, who knew what he was signing and what it entailed. President Trump also knew that Ukraine desperately needed the aid and America's partnership in its efforts against the huge power, Russia. He used that vulnerability to his advantage. He privately demanded that in exchange for United States aid and a White House meeting for Ukraine's newly elected president, Ukraine's leaders had to publicly announce an investigation that would damage his political rival, Vice President Joe Biden. The president relayed those same demands to senior Ukrainian officials through both private and official government channels. This was a clear quid pro quo, and it's at the heart of the argument in the first article of impeachment, abuse of power. President Trump took this action to benefit himself personally and not for the good of the nation. He violated the law by withholding appropriated funds in order to benefit himself and not our country. President Trump did not withhold these funds because of concern about corruption generally. Instead, he demanded just two specific investigations, Burisma and Biden, both intended to help him win re-election in 2020. After hearing the House manager's presentation, I think we've got to really ask ourselves, how can this president deal with any foreign nation after compromising himself in such a fashion? How can he be trusted to ensure that American elections are free from foreign interference? Other countries are watching. After the president compromised himself this way with Ukraine, what's to keep them or any other country from seeking benefits from the president in exchange for political or personal assistance? So, if the Senate refuses to correct this precedent now, the door to foreign political influence in our elections will be opened. The House managers also presented a strong case on the second article of impeachment, obstruction of Congress. Here, the facts themselves are not in dispute. President Trump ordered his administration to withhold all documents and ordered executive branch witnesses not to testify before the House began its inquiry. The president's legal team countered that he has a right to defy congressional subpoenas as a matter of executive privilege. But there's no precedent for their sweeping claim of absolute immunity from congressional oversight, particularly in the context of impeachment proceedings. President Trump has taken the position that there are no checks on his presidential authority, effectively placing himself above the law. And I don't believe the Senate can let this stand. Unfortunately, the president's actions are not isolated incidents. Both articles of impeachment point to this. The articles note, and I quote, "These actions were consistent with President Trump's previous invitations of foreign interference in U.S. elections, and with," quote, "previous efforts to undermine United States government investigations into foreign interference in United States elections," end quote. During the 2016 campaign, President Trump welcomed Russia's assistance to defeat his opponent, Hillary Clinton. The Mueller report detailed exactly how the Trump campaign sought to work with Russia to improve his electoral chances, including providing internal campaign polling data, to a Russian operative, inviting Russia to hack Hillary Clinton after Russia had already successfully hacked the Democratic National Committee, and obtaining information about upcoming releases of emails stolen by Russian agents, and weaponizing these stolen documents to harm Hillary Clinton. When this conduct came under question, President Trump obstructed the investigation. Special Counsel Mueller cataloged not one or two, but 10 clear instances where President Trump sought to interfere in this investigation. This isn't my view. This isn't anyone else's view. It's a catalog of a group of legal professionals indicating 10 clear instances where Trump sought to interfere in the investigation. This egregious pattern of soliciting foreign interference and blocking any effort to investigate continues to this day. As recently as October, while the House impeachment inquiry was going on, President Trump stood on the White House lawn and asked China to investigate the Biden family. This trial must do impartial justice, as is required by the oath we all took. After listening to the arguments of both sides, it's clear the House managers have proven their case. The president's conduct with respect to Ukraine has mirrored other parts of his presidency, and it's all about what is best for President Trump. If we vote to acquit and allow President Trump's behavior, we will set a dangerous precedent, one that has the strong possibility of inflicting lasting damage on our country. We will be saying that any president, Republican or Democrat, can leverage their office for personal political gain. We will be inviting more foreign interference into our elections and saying it's acceptable to use the presidency to solicit that assistance. His defense counsel admitted as much. And we'll be accepting the president's extreme view that Article 2 of the Constitution gives him the right to do whatever he wants. I'm convinced this is a rare instance where this Senate has no choice but to vote to convict and remove this president. I reach this conclusion reluctantly and with deep concern, but with the belief that this action is necessary and cannot and should not be ignored. Madam President, I ask unanimous consent that this statement be printed in the final record, and I thank you.
Without objection.
Thank you. I yield the floor.
Madam President.
Senator from Virginia.
Madam President, before I get started on my comments, I want to commend my colleague from California who has served in this body with great distinction for a long time, who was present during the preceding impeachment proceeding with President Clinton, who time and again, and I've had the honor of following in her shoes on the Intelligence Committee, has always been a voice that stood up for what's right, for what's correct, oftentimes what may not be politically expedient, but what she thinks is right and appropriate. And it's with great honor that I follow her as I make my statement as well on this most serious of matters, the impeachment of Donald J. Trump. So I thank my friend, the senior senator from California, for her comments, and I will echo many of her thoughts. Madam President, I want to begin my remarks the way we began this trial, with the oath we each took to do impartial justice. Now, any other day, we walk into this chamber as Republicans and Democrats, but in this trial, we have a much greater responsibility. The allegations against this president are grave. The House managers presented a compelling case based on the testimony of more than a dozen witnesses. And the remarkable thing about the dozen witnesses that we saw clips of, all of these witnesses were either appointees, political appointees of President Trump, or career public servants. And the fact that these dozen-plus witnesses had the courage to speak truth to power when they knew that their careers, their reputations would be sullied, in many ways speaks volumes. Their testimony and the House manager's case presents a clear fact pattern, a fact pattern that even many of my Republican colleagues acknowledge is true. This evidence reflects a corrupt scheme to solicit foreign interference in support of this president's reelection. The president both unlawfully withheld aid to an ally at war with Russia, and he withheld a White House meeting that would have strengthened our relationship with the democratically elected leader of Ukraine, a leader that was trying to prevent further Russian occupation of his country. The president used these powerful tools of American foreign policy as leverage, not leverage to further advance America's national interest, but leverage to secure investigations into a political opponent. He also used these as an opportunity to try to expound on the so-called CrowdStrike conspiracy theory, a notion that has been repeatedly debunked by Mr. Trump's own law enforcement and intelligence agency heads. A theory that somehow it was Ukraine, not Russia, that attacked our democracy in 2016. A theory, by the way, that currently has been and continues to be promoted by the Russian spy services. Since this information came to light, the president has attempted to confound the House of Representatives' constitutional role in the impeachment process. The White House issued a blanket refusal to provide any witnesses or documents without any historical precedent or sound legal argument to support this position. For this reason, President Trump is also charged with obstruction of Congress. Frankly, I understand some of the points the president's defense team has raised concerning this second article of impeachment. There are legitimate questions to consider about executive privilege and separation of powers. But we cannot accept the absolute immunity arguments this White House has invented. This absolute stance and the evidence we've seen about the president's corrupt actions and intentions do not reflect a principled, good faith defense of executive privilege. Rather, it suggests an effort to deny Congress the constitutional authority to investigate presidential wrongdoing and ultimately to prevent exposure of the president's conduct. In reviewing this evidence, I've tried to stick to my oath of impartiality. I've tried to keep an open mind about what witnesses like John Bolton and Mick Mulvaney, people who were in the room with the president, could tell us. If anyone can provide new information that further explains the president's actions, it is them. But I don't see how the White House's desperate efforts to block witnesses is anything but an admission that what they'd say under oath would not be good for this president. And I'm deeply disappointed that the Senate could not achieve the majority necessary for a full, fair trial. So consequently, the defense of the president that we're left with is thin, legalistic, and frankly cynical. Instead of disputing the core facts, which are damning on their own terms, the president's lawyers have resorted to remarkable legal gymnastics. The notion that even if the president did what he's accused of, abuse of power is not impeachable, that foreign interference is not a crime, that even calling witnesses to seek the truth about the president's actions and motivations might somehow endanger the republic. And then, when Professor Dershowitz made his bizarre argument that abusing presidential power to aid your reelection cannot be impeachable if you believe your own election to be in the national interest, I paid close attention. Frankly, closer attention to what Professor Dershowitz said in this chamber than I paid when I was in his class back in 1977. But you don't need a Harvard Law School degree to understand what utter nonsense that argument is and where it could take us if we followed it to a logical conclusion. The framers wrote impeachment into the Constitution precisely because they were worried about the abuse of presidential power. And if an abuse of power is what the framers had in mind when they crafted impeachment, then the two questions remaining in our deliberations are simple. Did President Trump abuse his power, and should he be removed from office? The House managers have presented a compelling case that the president did pressure Ukraine to announce politically motivated investigations. Again, a number of my Republican colleagues have acknowledged these facts, acknowledged that what the president did was wrong. And frankly, it's clear why he did it. Does anyone here honestly believe that Donald Trump wanted an investigation into the Bidens for any other reason than to damage Joe Biden politically and therefore aid in his own reelection? Time and again, this president has shown a willingness to attack anyone who stands in his way, and on this he's ecumenical. Republicans, Democrats, members of his staff, members of this body, nobody is off limits. There is nothing out of character about this president using every available tool to damage an opponent regardless of their political party. Now, I don't find fault for the president in his unorthodox style. That is not an impeachable offense. The long list of things I disagree with this president on are not impeachable offenses either. But the Constitution draws a line that is much clearer than the president's lawyers have tried to argue. The president crossed it. He abused his power. He commandeered America's foreign policy not to advance America's interest, but to advance Donald Trump's political interest. And despite his efforts to cover it up, he got caught. Now, each one of us must vote, guilty or not guilty. I will vote to convict the president because I swore an oath to do impartial justice. And the evidence proves the charges against him are true. There must be consequences for abusing the power of the presidency to solicit foreign interference in our elections. If the Senate fails to hold him accountable, we will be setting a dangerous precedent. We will be giving the green light to foreign adversaries and future presidents that this kind of behavior is okay. I will vote to convict the president because it is the Senate's constitutional responsibility to uphold this bedrock American principle that no one is above the law, not even the president, and especially not the president. Thank you, Madam President, and I yield the floor.
Madam President.
Senator from Montana.
Thank you, Madam President. I'm going to read a statement, and then I'm going to go back through the information that I used to make the decision to be able to write this statement. Montana sent me to the U.S. Senate to hold government accountable. I fought to allow this trial to include documents and testimony from witnesses with firsthand knowledge and allegations against the president, regardless of whether they were incriminating or exculpatory, so that the Senate could make its decision based on the best information available. Unfortunately, my Republican colleagues and the administration blocked this information, robbing the American people of their legitimate right to hold their elected officials accountable. Based on the evidence that was available to me at this trial, I believe President Trump abused his power by withholding military aid from an ally for personal political gain, and that he obstructed legitimate oversight by a co-equal branch of government. It is a sad day for this country, and for all Americans who believe that no one, not even the President of the United States, is above the law. So how did I get to this point? Well, just a little over 2 weeks ago, we came into this chamber and we started hearing testimony. That testimony resulted in these 2 notebooks full of notes, because quite frankly, the House managers laid out a compelling case. The defense made their arguments, but the case of the House was incredibly compelling. And impeachment is a solemn time. It's not something we should be taking without the deepest and most serious consideration. I compare it to a vote to send our people to war. But in this particular case, there was very little transparency, and none, if the President would have had it his way, of information coming to this body during this trial. This, in fact, is the shortest impeachment trial of a president ever. And if we're going to have information to make good decisions, and I've always said if you have good information, you can make good decisions, the President really needed to open up and cooperate just a little bit. This is the first time ever that we've had a trial with no witnesses and no documents, a trial in the Senate. No information from the executive branch. And I get it. I get executive privilege, and I think there are times when executive privilege has got to be used because the information is sensitive. But I've got to tell you, the Williams letter is a prime example. I went down to the SCIF, I read it. I've got to tell you something, if there's something in there that needs to be classified, you've got me. The information in that letter was information that I knew before I went in the SCIF. And it's the same with many of the emails, if not all of the emails, that the President has requested to be classified and kept away from this body and kept away from the press. And that's not the way this democracy should work. It should be open. If things are done, the people should be allowed to know. Now, there are moments in time when documents have to be classified on sensitive information. But I am here to tell you I've seen none of that. And I think many of the FOIA requests that have been brought forth shows heavily redacted email messages, and when we find out what's really in them, there was no need for that redaction. So when it comes to the obstruction of Congress, the Article 2 impeachment, I don't think there's any doubt that the President obstructed our ability, the Senate of the United States, to do its job as a co-equal branch to make sure that the executive branch is being honest and forthright. Now let's talk about the abuse of power. There's a lot of information that was brought forth during this trial about what the President did. It's been stated many times on this floor over the last nearly 3 weeks. The fact of the matter is there is little doubt that the President withheld aid to an ally for the purpose of creating a position where they had to do an investigation if they were going to get that money, or at least announce that investigation, on a United States citizen who happened to be a political foe to corrupt our next election. There's no doubt about that. Many of the folks who are not going to vote for impeachment have already said that the President has wrongdoing, but it's not an impeachable offense. And I am here to tell you, if anybody in this country, especially the President of the United States, corrupts an election, and that's not an impeachable offense for the President of the United States, I don't know what is. Fair elections are a foundational issue for this country. And to corrupt our elections is something that we need to hold people accountable of if they've done it. And I will tell you that the prosecution proved that point beyond the shadow of a doubt. I would also say that if you take a look at the episodes that happened before we got to this point that have actually nothing to do with the impeachment, but it does have something to do with the point that the defense said about folks have been calling for impeachment since this president got in office. I offer you this. Freedom of speech is something that is very important to this country. And I can tell you that when the president first got into office and he got in a fight with the Prime Minister of Australia and the Prime Minister of Sweden, and got in a fight with the Prime Minister of the best friend the United States has in Canada, I was critical of the president. When the president pushed back on NATO, it embraced every dictator in the world, from Putin to Erdogan to Xi to Kim Jong-un. Yes, I was critical of the president. When the president pulled troops out of northern Syria and left our allies, the Kurds, on the field alone, I was critical of the president. And when the president did his trade wars that put American farmers, family farmers, and Main Street businesses at risk of closure, I was critical of the president. And we should be. That had nothing to do with the impeachment, but it absolutely has everything to do with our freedom of speech. And tomorrow I should say, we're going to vote on whether to convict or acquit the president on taking taxpayer dollars and withholding it to an ally who's at war with an adversary for his own personal and political good. And we're going to vote on whether to convict the president of withholding information from the entire executive branch, and the only ones that testified were those patriotic Americans that defied his order. And we're going to vote whether he obstructed Congress. This is a no-brainer. He absolutely, unequivocally is guilty of both Article 1 and Article 2 of the impeachment. So the question is this. If it goes as predicted tomorrow, and the president gets acquitted, where do we go from here? I am very concerned about where we go from here, because the next president will use this precedence to not give any information to a co-equal branch of government when we question them. The next president will use this as, geez, if it's good for me in my election, it's good for the country, as Dershowitz said. So Katie, bar the door. And as Chairman Schiff said yesterday, if you think this president's going to stop doing these actions, you're living on a different planet than I'm living on. This will empower him to do anything he wants. And at some point in time, if we want to listen to what the framers said, at some point in time, we're going to have to do our constitutional duty. It doesn't appear we're going to do it this time. I yield the floor.
Madam President.
Senator from Maine.
Madam President, for more than 200 years after our Constitution was adopted, only one president faced an impeachment trial before the United States Senate. That was Andrew Johnson in 1868. But now we are concluding our second impeachment trial in just 21 years. While each case must stand on its own facts, this trend reflects the increasingly acrimonious partisanship facing our nation. The founders warned against excessive partisanship, fearing that it would lead to instability, injustice, and confusion, ultimately posing a mortal threat to our free government. To protect against this, the founders constructed an elaborate system of checks and balances to prevent factions from sacrificing both the public good and the rights of other citizens. Impeachment is part of that elaborate system. The founders set a very high bar for its use, requiring that the president may only be removed by a 2/3 vote of the Senate. The framers recognized that in removing a sitting president, we would be acting against not only the office holder, but also the voters who entrusted him with that position. Thus, the Senate must consider whether misconduct occurred, its nature, and the traumatic and disruptive impact that removing a duly elected president would have on our nation. In the trial of President Clinton, I argued that in order to convict, we must conclude from the evidence presented to us with no room for doubt that our Constitution will be injured and our democracy suffer should the president remain in office one moment more. The House managers adopted a similar threshold when they argued that President Trump's conduct is so dangerous that he must not remain in power one moment longer. The point is, impeachment of a president should be reserved for conduct that poses such a serious threat to our governmental institutions as to warrant the extreme step of immediate removal from office. I voted to acquit President Clinton, even though the House managers proved to my satisfaction that he did commit a crime because his conduct did not meet that threshold. I will now discuss each of the articles. In its first article of impeachment against President Trump, the House asserts that the president abused the power of his presidency. While there are gaps in the record, some key facts are not disputed. It is clear from the July 25th, 2019 phone call between President Trump and Ukrainian President Zelensky that the investigation into the Biden's activities requested by President Trump was improper and demonstrated very poor judgment. There is conflicting evidence in the record about the president's motivation for this improper request. The House managers stated repeatedly that President Trump's actions were motivated solely for his own political gain in the 2020 campaign. Yet the president's attorneys argued that the president had sound public policy motivations, including a concern about widespread corruption in Ukraine. Regardless, it was wrong for President Trump to mention former Vice President Biden on that phone call, and it was wrong for him to ask a foreign country to investigate a political rival. The House Judiciary Committee identified in its report crimes that it believed the president committed. Article 1, however, does not even attempt to assert that the president committed a crime. I sought to reconcile this contradiction between the report and the articles in a question I posed to the House managers, but they failed to address that point in their response. While I do not believe that the conviction of a president requires a criminal act, the high bar for removal from office is perhaps even higher when the impeachment is for a difficult-to-define non-criminal act. In any event, the House did little to support its assertion in Article 1 that the president will remain a threat to national security and the Constitution if allowed to remain in office. As I concluded in the impeachment trial of President Clinton, I do not believe that the House has met its burden of showing that the president's conduct, however flawed, warrants the extreme step of immediate removal from office. Nor does the record support the assertion by the House managers that the president must not remain in office one moment longer. The fact that the House delayed transmitting the articles of impeachment to the Senate for 33 days undercuts this argument. For all of the reasons I have discussed, I will vote to acquit on Article 1. Article 2 seeks to have the Senate convict the president based on a dispute over witnesses and documents between the legislative and executive branches. As a general principle, an objection or privilege asserted by one party cannot be deemed invalid, let alone impeachable, simply because the opposing party disagrees with it. Before the House even authorized its impeachment inquiry, it issued 23 subpoenas to current and former administration officials. When the House and the President could not reach an accommodation, the House failed to compel testimony and document production. The House actually withdrew a subpoena seeking testimony from Dr. Charles Kupperman, a national security aide, once he went to court for guidance. And the House chose not to issue a subpoena to John Bolton, the national security advisor whom the House has identified as the key witness. At a minimum, the House should have pursued the full extent of its own remedies before bringing impeachment charges, including by seeking the assistance of a neutral third party, the judicial branch. In making these choices, the House substituted its own political preference for speed over finality. The House managers described impeachment as a last resort for the Congress. In this case, however, the House chose to skip the basic steps of judicial adjudication and instead leapt straight to impeachment as the first resort. Therefore, I will vote to acquit on Article 2. Madam President, this decision is not about whether you like or dislike this president, or agree with or oppose his policies, or approve or disapprove of his conduct in other circumstances. Rather, it is about whether the charges meet the very high constitutional standard of treason, bribery, or other high crimes or misdemeanors. It has been 230 years since George Washington first took the oath of office, and there are good reasons why during that entire time the Senate has never removed a president. Such a move would not only affect the sitting president, but could have unpredictable and potentially adverse consequences for public confidence in our electoral process. It is my judgment that except when extraordinary circumstances require a different result, we should entrust to the people the most fundamental decision of a democracy, namely, who should lead their country. Thank you, Madam President.
Madam President,
Senator from New Jersey.
thank you very much. In 1974, after the House Judiciary Committee voted to approve articles of impeachment against President Nixon, Chairman Peter Rodino of my home state of New Jersey, a lifelong Newark resident of my home city, who had been thrust into the high-profile position only the previous year, returned to his office and called his wife. When she answered the phone, this chairman, this longtime congressman, broke down in tears and cried. 46 years later, our nation has found itself under similar duress. And God, I agree with my fellow Newarker. Impeaching a president is a profoundly sad time for our nation. It is a painful time, no matter what party. If you love your country, then this is heartbreaking. When we think about our history as Americans, so many of us have reverence for our founding fathers and our founding documents. They represented imperfect genius. We talk about the Declaration of Independence. We hail the Constitution. These documents literally bent the arc of not just our own history, but human history for democratic governance on the planet. And while these were milestones in the paths of our nation's relatively brief existence, the governing document that came between the Declaration of Independence and our Constitution is often overlooked, the Articles of Confederation. With the benefit of hindsight, it's easy to view the development of our nation as preordained, inevitable, as if it was an expected march towards the greatness we now collectively hail. That this was somehow a perfectly plotted path towards a more perfect union. But it wasn't. In 1787, as our founders gathered in Philadelphia, our fledgling country was at a crisis and at crossroads. And its future, like in so many moments of our past, was deeply uncertain. You see, when the